Subcommittee report.
I am going to defer to staff
Okay.
unless Judge D. Leonardo has any comments, because I was not present for the last subcommittee meeting. So,
Yeah, I think Judge D. Leonardo would ask that for myself to present this evening. So we are prepared to do so. So there are 3 items on the agenda for the Guidelines Subcommittee. First, I will note that the Guidelines Subcommittee met virtually on November 21st to review these items. So I'm going to start with the first item on the Guidelines Subcommittee agenda. That is the proposed removal of select sentencing guidelines worksheet fields. For your reference, there is a corresponding memorandum for this item that is titled Proposed Removal of Select Guidelines Worksheet Fields. The Maryland Sentencing Guidelines Worksheet is primarily used to determine the recommended sentence guidelines and to record sentencing data. Prosecutors and parole and probation agents record worksheet information up to and through the recommended sentencing range portion, and then judges and or their designees provide sentencing information. Over the years, multiple fields have been added and removed from the sentencing guidelines worksheet. Currently, the worksheet contains more than 80 fields, making it a time-consuming process for justice partners to complete. Recognizing this, the staff reviewed the worksheet to determine if there are fields that are not being used very frequently and could potentially be removed. The review utilized 5 criteria to determine if there were any fields that could potentially be removed from the guidelines worksheet. These criteria are the following. First, the field is not used by the commission to inform guidelines and sentencing policy. Second, the field is not used by another state agency to perform its duties. Third, the field is not routinely listed as a field of interest by outside parties requesting the guidelines data. 4, the field is often left blank by our justice partners responsible for completing the guidelines worksheet. And finally, the information captured by the field is captured by another field on the worksheet. So it could have met that, those weren't mutually exclusive. That was an and or. So it met one of those 5 criteria, possibly more than one of those criteria. So utilizing that criteria, the staff identified the fields noted in Table 1 and Image 1 of the memorandum as meeting one or more of the 5 criteria. And those fields include victim court costs imposed, the 10 fields in the victim information section of the worksheet, the 50% of sentence announced for COVs, which stands for crimes of violence, and finally, the subsequent offender proven field. It is worth noting that the victim-related fields, which pertain to victims' rights at sentencing, were added to the guidelines worksheet at the request of Roberta Roper, who was the victim's representative to the Sentencing Commission at the time. That was actually during the Study Commission, which is the commission that preceded the Permanent Sentencing Commission. Those items were intended to reflect the extent to which victims' rights provisions were exercised at sentencing. For the reasons I've already noted, the staff believes the burden of collecting these data fields outweighs their limited utility. The Guidelines Subcommittee considered the staff's recommendation at its November 21st meeting, and by unanimous vote agreed to recommend to the full commission that the identified fields be removed from the Sentencing Guidelines worksheet. The proposed revisions to the Maryland Sentencing Guidelines Manual and the corresponding revisions in COMAR, the Code of Maryland Regulations, are listed on pages 6 and 7 of the memorandum. That concludes my summary. I'm happy to answer any other discussions, or otherwise I'll turn it over to the full commission for discussion.
Yes, Elder Bartlett.
thank you. Thank you for the memo and report. I was hoping you were going to say that number 2 on the memo was removed because it is present elsewhere, you know, that it applied to the last item. What was it, number I don't know where it is that you mentioned, number
Number
five.
2 was
Number five.
a grouping together of the victim
Information.
information questions. Is that what you're referring to?
Yep.
Okay.
So I was hoping that the reason why it was recommended to perhaps remove is because of because the information was captured somewhere else. But that's not the reason that you gave. Is there, what was, I didn't get a reason, quite frankly.
Oh, that's fine. And I may, in my summary, I may not go into full detail. It's a fair question. It may be captured, and I'm sure it is captured in other instances. Especially each court has an individual victims coordinator, so I think that can be collected at the individual county level. So it's not that it doesn't here, but it's not elsewhere on the sentencing guidelines worksheet. Or in any other capacity. The primary reasons for the victim questions is the burden that they present to the court and the prosecutor's office in reporting that information to us. Frankly, those are the questions that we get the most questions and input about, and that information considerably slows down the worksheet completion process. We looked at that more as when those questions were added to the guidelines worksheet in, the decision was made in the late 1990s, and they officially got put on the worksheet in 2001 because that was the study commission made the decision, and then all their recommendations, actions got carried forward and then adopted by the permanent commission. That was done at a time when there was a significant victims' rights movement, and I think there was lack of information about that. And so I think the commission felt compelled for those reasons to add the questions to the guidelines worksheet. However, we don't use that data in any way. The Sentencing Commission do not use those data in any way. And the feedback that we frequently get is those are difficult for the courts to obtain that information, and it slows down the completion process. So a lot of the information can't be provided until after sentencing. And so in terms of the process and the way the guidelines worksheet is completed, if the court waits to get that information, it leads to a less efficient and more untimely submission for guidelines worksheets. So over the years, we've added questions, most frequently because we're mandated to do by the legislature. We add fields to the guidelines worksheet. We've never removed. And the worksheet, frankly, is it takes time to complete these worksheets. It's not an insignificant task that we're asking the courts to do. So from the staff's perspective, and I'm speaking really in general to all these questions, we think that we may engender some goodwill by making it a little bit easier to complete the guidelines worksheet. In the end, the fields that we're removing don't produce good data. Because of that, it's because they're left blank so frequently. If someone came to me and said, I want to use this victim data that you collect to analyze trends in victiming in the state of Maryland, I would advise them not to use our data because it's not quality data. So I think when I kind of thought of it that way, that was kind of the most convincing point to me for a reason why there wasn't a compelling reasons to maintain that information.
Okay, that last part makes the most sense to me. Because, if it's not being used, then I get it. And I'm assuming that it's not being used with such a low rate.
Response rate, right.
Response rate, that it's not really necessary.
Right.
Okay.
First, I will note that I did vote in favor of the removal of this in the subcommittee. Has there ever been a request to use this data that you can recall?
The State Board of Victim Services, when we, I don't know if that's reported in the memorandum. The State Board of, specifically the victim data, I presume, the State Board of Victim Services. I gave them a presentation. I went down there when I forget where the meeting was, and they asked us to provide the data and gave the raw data, and the response was disappointment that it was so incomplete. So that is that. And there was one time the Prince George's County State's Attorney's Office, if I'm remembering correctly, if anyone on staff, one of the state's attorney's office did try and complete an analysis to look at how But again, that analysis was incomplete because it wasn't like they could accurately rely on how often. That was specifically, I think, if I'm remembering correctly, about how victim impact statements, whether oral or written impact statements, influence sentencing decisions. So there are two instances that's over 20 plus years.
As a former member of the board of directors of the Maryland Crime Victims Resource Center, I think it's important to note there will be blowback from them if this information is removed. I think the information is there to remind prosecutors in the court to take into account the laws relating to victims. And if this is removed, even though it's not useful data,
Mm-hmm.
I think we're gonna get some feedback, adverse feedback. Like, why are you doing this? That's what I think.
I think that's noted. That's fair. I also think it was never. I'm not sure how well thought out it was, where it puts the commission in the role of being the check-in to see if the prosecutors are completing these tasks. And I don't think that's necessary. I don't think the commission really thought through that. That's.
I agree with you. It's not the commission's. It's not the role of the commission. I agree with you.
Yeah.
I think I'm alerting commission members.
Okay.
Mrs. Roper's still around.
Oh yeah. Oh, absolutely.
Mrs. Roper's still alive.
Absolutely.
And her group has been fiercely advocating after the Syed case in Baltimore City for expanded victim rights. And so I do believe there's going to be some feedback if these items are removed. I just want to point that out. I also say I voted to remove it, so.
Doesn't remove any of the provisions related to victim rights. This is just collecting data to see whether those victims' rights were applied.
Mr. Johnson.
Yeah, I have some concerns about removing this too, the victim information specifically. I know it's not high quality data, but there's, in addition to does the commission use this to inform its decision making, part of the general, I think, goal of the commission or part of its public service is collecting usable data for researchers and other people in the field. And people do care. There's the research literature about the role of victims in sentencing. Doesn't matter if a victim completes a victim impact statement, if they show up at a sentencing hearing. And just getting rid of all of the victim information, to me, is collecting less information is a worse thing. I wonder if there might be a middle ground. Like, part of the burden might be because there's almost a dozen questions about victims. Some of them I look at and I'm not really even sure what the difference is, between victim present or victim participation, right? There's all of these pretty detailed things if it's an oral victim impact statement or a written one. So I guess I'm wondering, rather than throw the baby out with the bathwater, is there a middle ground where maybe we reduce this to a couple of things, like knowing whether there's a victim in a case seems useful. Knowing if the victim if there was any victim impact statement, or if they participated at the sentencing hearing, just as a yes, no kind of thing, seems useful. So I'm not sure if there's what other commissioners think, but maybe instead of just getting rid of it entirely, streamline it so that it's easier to complete, less of a burden. But you're not going to make people angry who are victim advocates, and maybe you even get more usable data if it's simpler to complete.
That's possible. We haven't considered that before, so I'm streamlining the questions, I think, would be an improvement. The people that are completing the worksheets probably wouldn't see it as a substantial improvement by just reducing the number of questions. It is interesting. I looked around. There's no other sentencing commission that collects victim-related information in the state. There might be
data sets, Dave, that have victim rates.
Oh yeah, but it's not like
and things like that.
Right, but not collected by sentencing commissions.
Jen Shaw.
I wasn't present for the subcommittee meeting. However, I think that there is something to be said for the fact that the Sentencing Guidelines Commission should not be the repository of all information criminal, and that our role is rather narrow. I am concerned, however, that this information may not be captured But I agree, I think that when we created the sentencing guidelines, it became a greater document that, we wanted to safeguard all this information. And that's not really what we do in sentencing guidelines. And so when you have a sentencing guidelines worksheet that says, was there a victim in the case? And you have to answer that question knowing that it's a property crime or it's a drug crime and there's no victim, or it's a handgun offense. And so then it creates this feeling that do we really need to complete all this information? And so more often people just skip over that whole section. And I think that goes to some of the non-compliance with filling out the entire one. So do we want to develop a different worksheet for non-victim crimes, or, and do we use the information? And I'm not saying the information is not useful, but is it useful to us? And are we to be the repositories for everyone's inquiry?
Mr. Finchie?
Thank you. I voted for the removal of these sections of the worksheet. I think that I have a very strong historical sense of what has gone on in this commission over the years due to the number of years I've served on it. There's no doubt in my mind that these questions were inserted for the purpose of influencing the court to make sure that victims' rights are recognized and the involvement of the victim is supported by the judge in every case. And that's why it started 25, 30 years ago. That was before data was a thing, as far as I'm concerned. And whatever developed in the form of it being used for data purposes, that sort of is more modern. Now in the trenches, in the courts, you can't move forward with a sentencing in front of a judge without there being some statement as by the prosecutor that the victim was contacted or the victim is present. Here's a victim impact statement. The probation officers reach out to the victims. The victims' rights, there's such a sea change in victims' rights and the recognition of the need for victims to be involved in sentencing since we inserted that in the guideline worksheet. And it is, to me, extraneous to the purpose of the sentencing guidelines. That's why I voted for it. I don't have a strong feeling, though, that if there were some questions that would gather data, important data, it should be included. These questions I submit do not. They're really just, they're just sort of, nobody ever knows what even to say about some of the questions. What's the right answer? If you can't like immediately figure out what the right answer to the question is, it's not a meaningful response that's being obtained. So, and I don't disagree with what Mr. Harvey says. If Ms. Roper or her committee had some specific better questions or had an objection to removing it, I would definitely want to consider that and hear about it. But as it stands right now for the uses that we have for those questions, I think that its removal is the correct thing to do right now. I want to table it and find more better questions or talk to the committee. I have no problem with that either.
Well, that's a quandary. Yes, Delegate.
I will say that I'm uncomfortable with removing it. I will also say, however, I do see redundancy, where I think I agree with you that we can combine some of them. Victim participation is not really needed if you're going to ask if there was a victim impact, because obviously one can infer that there was victim participation. I don't even know what that means, victim participation. So that one, some of these I think could go away, and victim itself can go away. I guess they're asking if there was a victim. I guess you're starting if there was a victim. So, I don't know, I don't feel comfortable, Ms. Roper has come down to the General Assembly, and I've seen her, I've looked her in the eye, so I don't feel comfortable, removing it. I would feel comfortable consolidating, some of them, if that is an option. And I'm looking at the little box that says victim information. The other box over here, that might be a whole nother section on the subsequent, I think that's a different number.
Right.
I just wanted to look at,
There is a separate section at the top under ethnicity about the victim court costs imposed, excuse me, which is related, but that's a,
okay, here we are. Yeah, so I think the victim information is my point of concern. And I think we could highly minimize that to, almost 2 questions. Because no contact requested, no contact ordered. The request is, I guess, by the victim, and the order obviously is by the judge. But I mean, I just think that I don't feel comfortable getting rid of it. That's all I can say. I don't feel comfortable.
So with that, can I just move
Yes.
that we table the issue
Okay.
and resubmit it to the subcommittee for further discussion in light of the conversations?
Could I just
Second that.
just add to that
One moment.
discussion?
Go ahead.
We table it, but we also reach out to the Maryland Crime Victims Resource Center. They may not actually oppose this. I don't know. They probably will. But I think if we expressed, as the subcommittee expressed our concerns that some of this information really doesn't belong, it's not really our function, they would understand.
right.
And we could move forward perhaps with a consensus so we don't get that feedback.
I feel
So
more
you're
comfortable.
proposing to share the recommendation of the subcommittee with respect to those specific fields to remove with the Maryland crime victims, so that and ask them for their position on removing those specific sections? Yes, Mr. Johnson?
My question is there historical data to find out why the questions were put on here in the beginning?
I think Mr. Finchy spoke to that a little bit and said that
Sure.
I'm
initially
sure of it too.
It was to make courts
influence.
more aware
Okay.
of victims' rights and
And
the
prosecutors.
needs to contact the victim. At the beginning of my career, victims never engaged for sentencing. Nobody ever listened. The court would say, this is the court's job to determine the proper sentence. And the victim's input was rarely,
So all of these were added on at the same time. They weren't staggered.
there might have been.
They all were at the same time.
Yeah, all at the same time, like
Yeah.
30-some years ago.
Okay.
Like
Let me
1999.
just add that
One moment, because Ms. Guarino has not had an opportunity to speak.
I just want to
You might have to turn it up underneath.
I'll just project a bit.
There you go.
I think we're very sensitive at DPSCS of the concern of the weight that is put on existing data systems to capture every question that people may have about the criminal justice system. However, we also suffer from the issue of there being a dearth of complete information about victims. I'm just wondering whether or not the subcommittee examined what other data systems within Maryland's criminal justice system may have some of these data points, because that's a very different discussion to have as to what regarding redundancies. If there's a crosswalk or a pathway towards maintaining and having clear access to that information, if it exists in MDEC somewhere, that's a very different consideration that might prioritize which questions can only be captured on the sentencing guidelines versus maybe which could be pre-filled or other options for the state's attorney's offices to maybe gather some of this at a different stage, to adopt more of a proactive strategy towards resolving those barriers that result in the low completion rate, rather than treating the low completion rate as evidence of what is possible, which is what is maybe possible, how we're using our current data landscape, which is very different than it was in 1998.
victim notification is filed in MDEC by the state's attorney in any case that is relevant to that. So I know that by the way, it's something that never happened 30 years ago. There was no such thing as required victim notification. So now it's a pleading in nearly every, I think every violent crime case or every victim case. You know? So, as I said, major sea change since these were created. And maybe the point would be for David to tell the committee that we don't think we're getting good data. We don't think these are good questions that we're asking. If you have other questions, we could, maybe 2 or 3 really black and white questions that would gather data that maybe would be important for you. That's something we could consider.
Do you want to state your motion again?
My motion is that we table any further consideration of the subcommittee's report until we have had the opportunity to reconvene and reconsider.
Second.
Thank you. It's been moved and properly seconded that we table the issue regarding removing the victim categories on the guidelines worksheet and send it back to the subcommittee for review. All those in favor? All those opposed? Thank you. Motion carries.
All right, thank you. So let's move on to the next item on the agenda, and that is the proposed classification of previously unclassified offenses. And I am going to ask Ms. Nozell from our staff to provide an introduction for the next two, for the proposed, the unclassified offenses and then the proposed reclassifications. I'll turn it over to Bella.
Can you hear me okay? Awesome. All right, good evening. I will refer you all to the memorandum labeled Proposed Classification of Previously Unclassified Offenses. There are 3 offenses in this memorandum to review. First, the MSCCSP staff were contacted by criminal justice practitioners regarding 2 offenses not contained in the guidelines offense table. These offenses, which are listed on page 1 of the memo, are obtaining or attempting to obtain a driver's license or moped operator's permit by misrepresentation, and failure to provide satisfactory documentary evidence of lawful status and valid social security number when applying for an identification card. A violator of these offenses is guilty of a misdemeanor with a maximum penalty of 3 years and/or a fine of up to $2,500. Based on the comparable offenses listed on page 2 of the memorandum, the subcommittee recommends classifying both offenses as property offenses with a seriousness category of 7. Additionally, on page 3 of the memorandum, the MSCCSP staff identified a 3rd offense as being previously unclassified while reviewing the new and revised penalties from the 2025 legislative session. This offense is a subsequent violation of providing heating, ventilation, air conditioning, or refrigeration services without a license, employing unlicensed individuals, misrepresentation as a license holder. A violator of this offense is guilty of a misdemeanor with a maximum penalty of 2 years and/or a fine of up to $5,000. Based on the comparable offenses listed on page 4, the Guidelines Subcommittee recommends classifying this offense as a property offense with a seriousness category of 7. That concludes my summary. We are happy to answer any questions. Otherwise, I'll turn it back over to the commission.
Are there any questions? The motion is to adapt the classification of the proposed classification as recommended by the subcommittee. Are there, there's no questions. All those in favor? All those opposed? Thank you. Motion carries.
Perfect. I will refer you now to the next memorandum titled Proposed Reclassification of Health Occupation Article 14-5C-23A. While reviewing the new and revised penalties from While reviewing the new and revised penalties from the 2025 legislative session, MSCCSP staff noticed that the offense, practicing polysomnography without a license, is currently classified as a property offense when similar practicing without a license offenses are classified as person offenses. Polysomnography refers to a sleep study used to diagnose sleep disorders. This offense was originally classified at the MSCCSP's June 5th, 2006 meeting. However, there is no record of discussion about the offense type classification. Based on the comparable offenses listed on page 2 of this memorandum, the Guidelines Subcommittee recommends reclassifying Health Occupation Article 14-5C-23A from a property offense to a person offense. That concludes my summary. We are happy to answer any questions. Thank you.
Thank you, Bella. One thing that came up during the subcommittee discussion, though, that is an excellent question, was, why was this offense originally in 2006 classified as a property offense? And I thought Bella provided a strong answer, because we looked back at the memorandum and most of the comparables at the time were like fraud-related offenses, not necessarily this level of offense where it's, where we now have more comparables about doing something without a license that could potentially cause harm to individuals. So that is the likely answer that we deduced why it was originally classified as a property, but think now that it's more appropriate to be a person offense.
Thank you. The motion is to adopt the recommendation of the Guidelines Subcommittee to accept or adopt the reclassification of practicing polysomnography from a property offense to a person offense. All those in favor? All those opposed? Thank you. The motion carries.
Okay, the last item on the subcommittee is not a action item. This is a status report only. I just wanted to give a status report on proposed revisions for scoring physical victim injury. So as you may recall, this commission voted at its September 9th, 2025 meeting to adopt new language defining psychological victim injury for the purposes of scoring Part C of the offense score. And after a thorough review of the definition of psychological injury, the subcommittee expressed interest in possibly expanding and reviewing the definition of physical victim injury. The subcommittee presented this recommendation to the commission at September meeting, and the commission voted to assign the review to the subcommittee. So the subcommittee met on November 21st, and we did discuss proposed revisions to the definition of physical injury. The subcommittee reviewed how other sentencing commissions score physical victim injury and agreed that the Maryland Sentencing Guidelines Manual should provide examples of non-permanent and permanent victim injuries. The subcommittee plans to continue this discussion at its next meeting and to hopefully present proposed revisions to the scoring instructions for physical victim injury to this full commission at our next meeting, which will likely take place in May 2026. We had a very spirited debate and a really informative discussion, and I think the subcommittee generally agreed on some principles, but wanted just some more time. And also, we wanted to allow Judge Shaw to have further input on that topic. So we did agree to table it and just give a status update this time.
Thank you. We will now move on to the executive director report.
All right, more of me talking. Yay. All right, I have 6 items to review. So the first item is the November 3rd, 2025 sentencing guidelines revision. So the commission issued a new version of the Maryland Sentencing Guidelines Manual and the Guidelines Offense Table, and corresponding updates were adopted in the Code of Maryland regulations effective November 3rd. The amendments modify Regulation 12 under COMOR 142201 General Regulations, and this was done in response to Senate Bill 152, House Bill 89 from the 2025 session, which provides that each animal harmed in violation of the criminal law article Title 10, Subtitle 6, shall be considered a victim for purposes of applying the multiple victim stacking rule. Additionally, the amendments modified Regulation 02 under COMAR 142202, which is the guidelines offense table. So this added new and revised penalties from the 2025 legislative session. And there were some other minor edits to the table, including the addition of new CJIS codes for several existing offenses. The second item I wanted to provide an update about is forthcoming January 1, 2026 sentencing guidelines revisions. I noted this during the public comments hearing, but We had proposed COMAR amendments that were published in October, in the October 17, 2025 edition of the Maryland Register. Those proposed amendments reflect action taken by this commission at its September 9th meeting, and those are with respect to the psychological victim injury, which I just discussed earlier. Additionally, the proposed amendments modify Regulation 15 under COMAR 142201 to instruct that when an individual is being sentenced for multiple violations, including contemporaneous violations of Criminal Law Article 4-204, which is use of a firearm in the commission of a crime of violence or any felony, or 4-306, which is the use of an assault weapon in the commission of a felony or crime of violence, the guidelines for all but the first violation of each offense shall be calculated pursuant to Criminal Law Article 4-204C2 or Criminal Law Article 4-306B3, respectively, both of which provide penalties for subsequent violations. The proposed revisions to this regulation include addition to the existing instructions for calculating guidelines for subsequent offenses, including subsequent drug offenses, subsequent crimes of violence, and other subsequent offenses. To note, the guidelines calculation rules described in these instructions are not new and are presently provided in Chapter 8.6 of the Maryland Sentencing Guidelines Manual. Lastly, the proposed amendments also offer additional updates to COMAR 14220202, which is, again, the guidelines offense table. And this is to reflect revised seriousness categories for 2 offenses and other minor edits to the table. And those amendments are expected to be adopted effective January 1, 2026. The third item I wanted to discuss is sentencing guidelines training and judicial feedback meetings. In September, our training coordinator, Catherine Penbrook, provided a webinar series titled Sentencing Guidelines and MAGS 101. There were 2 sessions that were offered on September 10th and September 19th. This was geared towards law clerk and other court staff to provide an orientation for them about sentencing guidelines. We time it in September to coordinate with the time generally that new law clerks start. Additionally, Ms. Penbrook provided a webinar on September 12th titled Refresher Sentencing Guidelines and MAGS 101. The target audience for this webinar was state's attorneys, parole and probation investigators, and defense attorneys. Additionally, since our last commission meeting in September, I met with the judges and court staff in 4 jurisdictions. First, I met with the judges in the Circuit Court for Prince George's County on September 18, 2025. Next, I met with Judge DeLeonardo and his colleagues in Carroll County on October 8th. Then I met with the Howard County Circuit Court and the state's attorney's representative and local office of the public defender representative on October 30th. And then finally, last but not least, I met with the judges in the Circuit Court for Calvert County, and along with representative from State's Attorney Bob Harvey's office and the local office of the public defender on November 3rd. I'm next scheduled to meet with the judges, prosecutors, and public defender in the Circuit Court for Anne Arundel on December 16th, and that'll wrap up my judicial feedback meetings for 2025. My goal is to meet with each jurisdiction every 2 years. The meetings are, I think, always a wonderful opportunity to share information about sentencing guidelines, to talk about whatever the Sentencing Commission is working on, to prepare data that is specific to their individual jurisdictions. And it's always an awesome opportunity to solicit feedback about the work of the commission. And we often get some of the ideas and topics that we explore frequently come from those meetings. So they're a great opportunity to get that type of critical input about our work. Finally, with respect to training, and bless you, I did want to provide an update. At our last meeting, Judge Shaw asked what sentencing guidelines training was provided for new judges, as new judges come to the bench. So in the response to that, Judge Middleton and I did reach out to the Judicial College. In the past, the Sentencing Commission did provide a training session during what is sometimes referred to as Baby Judge School, formerly called the New Trial Judges Orientation. However, a few years back, that new judges trial orientation was reformulated, and the guidelines training the portion was no longer included. So we reached back out again just to see if it was an opportunity. And unfortunately, timing wise, it was a little bit late to be included in the 2025 session, but we're hopeful that we'll be able to include a brief session at future new trial judges orientations. But we also learned that our colleague, Judge DiLeonardo, was heading up a sentencing session for the criminal law university training being provided by the judiciary. Judge DiLeonardo was not here at the September meeting, so he didn't know that that question had been asked. So that was awesome that we learned that he was doing that. And we were able to provide some handouts that he incorporated into his materials for his training that he provided for the criminal law university, because he was specifically speaking on the sentencing portion. So hopefully in future years, we will have more details and more information included about the sentencing guidelines. For every new judge that is appointed, I do want to note that Catherine Penbrook does send out a letter from our staff, welcoming new judges to the bench. We do provide information very briefly and give them some, resources about the website and provide a new, laminated departure card, et cetera. So we give them just an idea if they don't know about our work a little first, but it would be better to have a session at the new trial judges orientation. So hopefully we'll be able to do that in the future. Okay. The fourth item I wanted to discuss, and I've been doing this annually for a while now, is to just review protocol for the Sentencing Commission response to legislative proposals. So in 2019, this commission adopted this protocol. The General Assembly session, as you all know, starts in January. And since we have some new commissioners, we have, turnover a year, I just want to kind of review what the process is for that. So in 2019 and 2020, and then I think it skipped 1 year back in 2022, there was legislation that was introduced that specifically required, actions from study or something for the commission to do. One of those ones was they wanted us to start reporting judge-specific information about the guidelines. And so we realized we didn't really have a protocol for how the commission responds, because typically this commission does not meet when the legislature's in session, right? Our first meeting of the year is typically in May, and the legislative session runs from January through April. So what we did was come up with a protocol to say, if there is legislation that is introduced that specifically impacts the works of the Sentencing Commission or directly affects the sentencing guidelines, then we will take some actions to address it. And that happened last year, I think twice. We had 2 bills that this commission met. So the protocol that I shared with all of you will just be that the staff and I will try to identify those bills as soon as we possibly can and reach out and notify Judge Middleton and the guidelines subcommittee. And then we will convene a meeting virtually of this group. Hopefully, it might be a brief meeting, but we've been able to do that, and try and quickly get the group together and just have a discussion and vote whether we're going to take any action, whether we need to support, oppose, or, take no position on a bill. So that policy I did share with you, and that I kind of tried to briefly describe it there. I'll just stop there and ask if anyone has any questions about that policy. For those of you who were here last year, it'd be the same thing. We did this twice with 2 specific bills that impacted the commission or the guidelines. Okay, not seeing any questions. Good. So if you hear from us, it'll be because there is a legislation that directly affects us. Okay, 2 more updates and then I'll be done. The 5th update is just letting you all know that the commission every year has an annual report, and it is due on January 31st of 2026. So that'll be our 2025 report is due on January 31st, 2026. It is something that takes the staff a fair amount of time to put together. We've already begun preparations for that, and we will distribute a draft for commissioners to review on or about January 16th. And then we say, please look this over and give us feedback within 1 week. So we'll follow that protocol. We are currently performing a number of data cleaning tasks that we have to do each year. And that's to prepare the guidelines data for all the analyses that are included in the report. So just wanted to give you an update about that and give you a heads up to expect a draft of that report on or about January 16th. And then we will incorporate your feedback and changes that are needed and make sure to submit that report by the required due date. The last item I wanted to provide an update on is the timeline for the study on the prior adult criminal record. So last year at the Commission's December 3rd, 2024 meeting, we provided an estimated timeline for the prior adult criminal record study. And in that timeline, we estimated receiving data by March 2025. Then we would analyze, the staff would analyze that data and present findings to the guideline subcommittee probably in November 2025, and then be prepared to present some findings and a potential report to the full commission in December, which would be this meeting. Unfortunately, we haven't yet obtained all the data that we requested. The process for obtaining the data was a bit more complicated than we expected. Accordingly, the timeline for the project must be revised. We are essentially pushing back the timeline by 1 year. But we did receive good news this morning regarding an updated memorandum of understanding with the receipt to receive that data. And we want to thank Assistant Secretary Guarino and her team for facilitating that. There was just a misunderstanding about what exact data points we needed in order to be able to do the analyses that we're hoping to do. And there's one field in particular, the CGIS code, which is very important to our analysis. So I think we figured that out, and hopefully we'll have that data soon, and we'll be starting to do that analysis early in the new year. So that concludes my report. I am happy to address any questions.
I have a question.
Sure.
The study for the prior,
Right.
on the prior adult criminal record, can you just inform the committee on what the importance of collecting that data is to our work?
Yeah, so the race report, which was mentioned in some of our public comment testimony that you all may recall, one of the things we noted is that prior criminal history has probably the most significant impact on sentence length, and has is one of the primary drivers of the observed differences, racial differences in sentence length and likelihood of incarceration. The commission, as most of you all know, the sentencing guidelines has a sentencing matrix. It's pretty complicated, but it is a tool that is used to provide a summary score that winds up with an offender having a score of either none, minor, moderate, or major. And it's basically a matrix which is used to count up the number of prior offenses and the seriousness of that. That is something that has not been revisited since the inception of the sentencing guidelines. And so the race report recommendation was to do that, to do just that, to revisit that data. In order for us to be able to do that analysis, we need the criminal history rap sheet data. That's not something that data the commission collects on our own via the guidelines worksheet. So on the guidelines worksheet, we know an offender is reported with a criminal history score of none, minor, moderate, or major. What we want to look at is exactly how that summary score is calculated, and look at that and consider whether any revisions might be considered. For example, one of the things that feedback that I got from a judge is saying, it really bothers me that someone can have a major criminal history score in the guidelines simply by accumulating a volume of relatively minor offenses. And is that something, should it be that way, I guess is the question the judge asked. So we need the data for the individual's criminal history, their rap sheet data, to be able to assess how often that is happening. And are there other instances like that where maybe someone accumulates a serious criminal history record, but it's based strictly off nonviolent offenses, or what type of offenses are included in that? So the data that we are requesting is not data that we have. So we have to get that criminal history data, and it's going to be a lengthy process for us going through that. But what we want to really do is just really examine how what components and what specific offenses are ultimately determining one's criminal history score, and then just have a discussion about that. As you may recall, we were making no promise about revisions to the criminal history scoring, but I think it's important for us to know how those criminal history scores are being calculated and what are the driving factors in that. So we need offense-specific data so we can tell exactly what offenses are being utilized to calculate those prior criminal history scores. Sorry, that was a long-winded response, but I was trying to.
It was. The reason why I asked that was particularly to inform or re-inform the committee about the report, especially in nature of the public commentary that we heard tonight. And a lot of the concern, or some concern, was whether or not what we were doing in light of the data that we collected and published in the report from 2023.
Right.
So I did think it was important for us to restate that, Mr. Finch.
I just had a question. And when you say rap sheet, what are you getting? Curious.
From the Department of Public Safety and Criminal History.
I mean, what sort of report are you getting from them? I mean, for an individual.
I'm happy to have our Assistant Secretary answer that question on my behalf.
You get like different things in your cases. I mean, some are accurate, some are not so accurate, some are much harder to work with than others.
Sure, I'm happy to speak to
Sure.
the standard data elements available in our criminal justice information system, which receives that information.
Can you just speak up a little bit? Because I think you turn it on underneath, if that helps. Like underneath the stand. Yep.
There's
Okay, sorry about that.
there.
Hey,
I promise I am normally much better with technology than this.
It's at the
Is that a little bit better?
Yeah.
Thank you. So the standard elements in the criminal justice information system by state identifying number would include any and all arrests, the arresting jurisdiction, the offense listed associated with the arrest, and then any charges brought, what court they were heard in, what sentence, the duration of the sentence, whether it was a sentence to incarceration or a sentence to probation, and all of the charges associated with those would be included.
Related to Maryland.
Yes, yeah, thank you so much. Yes, specific only to reporting agencies within Maryland.
Are we collecting information about incarcerable motor vehicle offenses?
Yes.
Okay, because that, you can, I'm not up to date on it, but you used to be able to get a major criminal history record with, 5 or 6, 7 driving suspendeds.
Correct.
So I think that's something we need to look at.
That's definitely something that's on our
Maybe
radar.
that's not so good.
Any other questions? Thank you.
Well, that concludes the executive director report.
All right.
So we can next.
Hold the applause. Oh.
Thank you. All right. So I think we want to go through some dates, proposed meeting dates.
Correct. So following our typical schedule, these dates should look pretty familiar. They're typically have been meeting in May, July, September, and December. I didn't put this on here. I apologize. Proposing that the May and December meetings would be in person, and the July and September meetings would be virtual. I did cross-check the September holidays with the Jewish holidays, so I think we're clear there. So I would just present those as the proposed calendar dates for 2026.
May and December in person.
May and December in person, correct.
Are you gonna bring sangria or something?
Oh, right?
This is the second time I went back and looked that we will have a Cinco de Mayo meeting. I think it does call for a specific something.
It's a sidebar.
Sombreros for everyone.
Okay. All right. Any old business? Any new business? Yes.
I just wanted to address a couple of questions that came up in the testimony. One question, well, 2 questions. One is with respect to the availability of the worksheets to convicted self-litigants. So for instance, I see that we supply to the
Right.
defense attorney, we get it. I shouldn't say we supply, but they supply to the defense attorney, et cetera, et cetera. So I'm assuming, even though it's not stated, that a pro se litigant or defendant would also receive a copy. Is that correct?
Yes, that is the protocol. So, we had to look that up ourselves.
Yeah.
I'm going to be frank. So, it is our understanding that pro se litigants now do get access to MDEC, which is the Maryland Electronic Courts. So that the individual who testified earlier, she was finding her worksheets in MDEC.
Yeah, okay.
I said worksheet. There really was, to be clear, there was one worksheet. It's just that it was scanned into MDEC in multiple different iterations. Like after the PSI was the first one, which is appropriate, and then after sentencing was the second one. Then they actually scanned in a third version, which was a corrected version, which that does happen from time to time. The fourth one she's referring to is all the same one. That was when we gave her the one we had, which matched what she already had. So it really wasn't 4 different worksheets. I want to make that clear. It was one worksheet that she did see entered into MDEC 3 times. So now I think there's no issue. Mr. Snipes, who was the last individual who testified, he was in 2016, which predates MDEC or MAGS. So it was, that is, I'm going to be honest here. The way the procedure is that the court clerk is to distribute the completed guidelines worksheet to the state, to the defense, and how that happens in pro se cases, I'm not sure what the protocol was there.
All right, gotcha. And so the other one was on the 7-year. That's the other question I was gonna ask. So I know we only came into
Right.
existence in, what was it, 1999? I forget, whenever the commission came into existence.
Right.
But the worksheets, are they destroyed? They're destroyed, so the clerk basically is saying that the clerk destroys them. Does the commission?
Yeah, I can clarify that.
Or is it just digitized?
Yeah, so just the paperwork. So it's actually not even, again, relevant now because in MAGS, we don't even get a paper worksheet, right? So it's all done online in MAGS. There is no paper worksheet sent to the Sentencing Commission, but the court does download a copy of the guidelines worksheet and scan it into MDEC. And they keep that in perpetuity. But we, the Sentencing Commission, in 2013, I think 2030 was correct. We, the Sentencing Commission, the staff came to this commission and said, we have 100,000 guidelines worksheets and paper worksheets, right? This is pre-MAGS. We are running out of space for them. We can't contain them. And we talked to the state archives and they said, of course, you need to have a data schedule retention policy. So we established a policy that was approved by the state archives where we keep hard copy paper worksheets for 7 years, and then it is destroyed. But keep in mind, the worksheet still exists in our database. The data doesn't get removed. It's just that paper worksheet. But a defendant can still get a copy of their guidelines worksheet from the court file. It's just that the commission doesn't have a paper copy to provide after 7 years. And now since MDEC was deployed statewide in 2019, we don't have paper worksheets. Now we can download it from MAGS like we did with these two and say, but we don't have like the hard copy guidelines worksheet. So yeah, that was our data retention schedule that we established, and then it was approved by the state archives.
Okay, that was my assumption. I just wanted to make sure. Thanks.
Okay.
But that did generate some thought of the availability of access. How do pro se litigants access their guidelines, especially if they receive a sentence and then may have questions about their sentence or how, what factors may have influenced the sentence that they received. So it was, to me, a question of when they can access their sentencing guidelines, especially if they are sentenced to a period of incarceration. Thank you. Is there any other new business? Yes.
Not necessarily new business, just a follow-up. Has the sentencing guidelines, has the commission rather put together any public-facing FAQ documents for pro se litigants? Because if so, that's something we would also be interested in making available through our electronic materials to incarcerated individuals who often are sometimes those pro se litigants,
Right.
just as to elevate clarity of direction for those individuals.
That's a good question.
I don't think they have, but that was actually one of Mr. Barry's recommendations. Was that we work on that we develop something information that we can tell the public, right, so that they can digest the guidelines and perhaps help them understand it now.
Right.
That will be the difficult.
I do want to comment there. I would say that we don't have a document on our website labeled, this is for pro se clients, but we do have quite a wealth of information available on our website that someone who is representing themselves can avail themselves to. There is a frequently asked questions section on our guidelines worksheet that addresses like the common questions about that. We have a guidelines calculator tool, so anyone could go in and calculate their own sentencing guidelines, right? They don't need access to MAGs. We have the Maryland Guidelines Manual, which is a PDF searchable document. We have YouTube training videos that, right, for how to use the guidelines calculator tool, what the guidelines 101. And we have all our annual reports and information. So there is a wealth of information out there. I wouldn't say there's a, hey, for pro se litigants, this is what you should do. But that, I mean, that's a fair question. That made me think for the first time, you know, what a pro se litigant does. It's uncommon, you know, it's less than, I looked last year, it was less than 1% of guideline sentencings were pro se. So it is uncommon. I don't know if it's increasing. I think the individual said that. I don't know if that's true, but we do have a wealth of information, I think, that is available. But they have, you know, they'd have to know to go to the commission's website to start with.
Well, is it possible to put that at the bottom of the worksheet? Since they have access to the worksheet from MHEC, could put it at the bottom of the worksheet? You know,
Is
URL.
our web address on the worksheet?
Because it's a good website.
It's great.
Thank you. Yeah.
It's a great website.
It's comprehensive.
Yeah, you're right. It's on like the guidelines calculator tool. It's in MAGs, but it's not printed on the worksheet. And they're, yeah, so that's a good idea. Okay. I like that option.
Anything further, any other new business?
I actually have a new business or announcement to make.
Okay.
So I'm very pleased to announce that this year, on October 1st, the Sentencing Commission Staff Research Director, Stacy Najeka, completed her 20th year at the Maryland Sentencing Commission. Although she's not here yet. Although she could not join us in person today, she is participating via Zoom. Hi, Stacy.
Hi there.
I know you do not love being the center of attention.
No, I don't.
But I couldn't let this significant milestone pass without publicly recognizing it and expressing how grateful I am that you decided to join our team 20 years ago. Stacy was my first hire as the new staff director, and give myself a little pat on the back because it was a great decision. So I just want to let you know. So Stacy wears many hats. I just want to give you a few examples of what she does. She has oversight of the Maryland Sentencing Guidelines database. That in and of itself would be a task, probably more than enough for one person. She also leads our staff analyses of the guidelines data, the data cleaning process, and all the analyses and thoughtful research that we include in our annual reports and in the memorandums, et cetera, that you receive. She also directs the staff production of the annual Managing for Results report, which is a required report that we have to do every year in preparation for our budget submission. She also has oversight of all the commission's data dissemination activities. So when people request data from the Sentencing Commission, Stacy is the one who is responding and taking the lead on that. And then finally, and this isn't a complete list. I was just kind of providing the big ones. She serves as the Sentencing Commission's Code of Maryland Regulations coordinator. So she's the one that's ensuring that all the changes to the commission's regulations and sentencing guidelines are accurately promulgated through COMAR. And that's actually a very painstaking process to make sure that those go through accurately. And in these many roles, Stacy has always demonstrated amazing research, leadership, and management skills. She has just the most incredible attention to detail. She is very often the final editor, and if you need something real quick, you want Stacy to lay her eyes on it. And she usually catches a minor mistake, so we appreciate her attentiveness and her thoughtful and deliberate decision-making. And last, but certainly not least, she is just a wonderful person, colleague, and friend. So on behalf of this commission and its staff, we thank Stacy for your 20 years of service, and we look forward to many more years to come.
Thank you so much. I really appreciate that. And I've really appreciated my work with the commission staff, and with all the commissioners. So thank you.
Is there any other?
None for me.
Business? All right, thank you. And with that, do we have a motion to adjourn?
So moved.
Meeting adjourned.
All right. Thank you, everyone. I hope everyone has a happy holiday season. We'll see you in May with Sombrero.